Imagine this: a terror incident is declared, and entire areas can be placed under a temporary no assembly regime. No authorized protests, no processions, no rallies, because police think a public gathering might make a reasonable person fear intimidation or violence. Mass terror attacks change laws, but whether those changes are too much or not enough. December 2025, and just before Christmas, in the wake of the Bondi Beach terror attack, the New South Wales government recalled Parliament urgently, introducing a sweeping terrorism and other legislation amendment bill and pushed it through in just days. I think this was a straightforward emergency response, but the parliamentary speeches and amendment battles show deep and sharp disagreements, not just about what should be done, but how, why, and how far. Today we will unpack the background and parliamentary context behind the bill, the key debates and actual amendments proposed in both houses, why most amendments were rejected, and how this New South Wales Act may influence or interact with Commonwealth's 2026 hate speech bill. Let's begin with the context. On 14th December 2025, a massive shooting in Bondi Beach left 15 people being killed and 40 injured, including 2 servicing police officers, the deadliest attack in New South Wales in nearly 30 years. Government leaders, in particular Chris Minns, said the attack revealed urgent gaps in terror-related laws. On 22nd December 2025, the New South Wales Parliament was urgently recalled, with standing orders suspended so the bill could be introduced without notice and go through all stages on the same day. This is rare because normally bills are notified in advance and considered over weeks. This urgency was justified by the need to protect community safety following the tragedy. Opposition members of Parliament acknowledged the shock and need for safety, but some members, including Kelly Sloan and Roy Butler, criticised the speed and lack of prior consultation. In a nutshell, the bill is a package to achieve several goals, including banning certain terrorist symbols publicly, tightening firearms licensing and categories, expanding police powers around face covering at protests, and creating a new mechanism to restrict public assemblies in a declared terrorist context. Now let's look at how those goals are achieved. The bill amended multiple existing legislations. Firstly, it amends the Crimes Act so that it becomes a standalone new offence of displaying prohibited terrorist symbols, with penalties up to 2 years imprisonment or significant fines. Secondly, it amends Firearms Act and regulations so that new restrictions are introduced on license duration, firearm categories, and possession limits. For example, after amendments, the firearm limit is generally 4 per license. This sounds like a fair number, given in New South Wales there are currently 250,000 licensees who hold about 1 million firearms. The limit can be up to 10 if they are possessed for genuine reasons such as primary production and occupational rural requirements. Sport or target shooters may apply for more. Thirdly, it amends Law Enforcement Powers and Responsibilities Act so that new powers are delegated for police to direct removal of face coverings at protests if police reasonably suspect the person may have committed or is likely to commit an offence. Fourthly, it amends Terrorism Police Powers Act. This is a big civil liberties flashpoint, and the New South Wales government's explanation when a terrorist incident is formally declared. The Commissioner or Deputy Commissioner with Minister agreement can declare specified areas when public assemblies are restricted for a limited period, so-called a Public Assembly Restriction Declaration. A strong signal will be sent to the community that assembly in public spaces in a designated area is unsafe and discouraged. Public Assembly Restriction Declaration once made will be lasting 14 days, extendable by 14 days periods for up to 3 months. Last but not least, the Act amends Summary Offences Act so that once a Public Assembly Restriction Declaration is made, Part 4 of the Summary Offences Act will not permit the Commissioner of Police, the District Court, or the Supreme Court to authorise a public assembly to take place in those restricted areas. It basically nullifies any existing authorisations planned for such areas. I've discussed the Part 4 of the Summary Offences Act in details and various exemptions protecting the participants in public assemblies in my previous videos. You may check them out if you are interested. As a consequence of the changes in the new Act, participants in unauthorized public assemblies in those areas will not be protected from criminal liability or obstruction offences. In summary, the statute now overrides some discretion that used to be reserved by the courts. The logic behind these amendments are that the assembly of a large group of people after terrorist attack can also give rise to a real risk to community safety, including to those participating in the assembly. by making those in the assembly a target and exposing everyone else to a risk of harm. In order to reduce these risks and keep the community safe, the bill proposes to create a scheme which would operate to prevent public assemblies from being authorized in designated areas for a defined period of time and allow police to use existing move-on powers to address any public assemblies that take place in such an area during that period. It would be interesting to observe the decision-making process of a public assembly restriction declaration, and in particular, how are those restricted areas to be identified. The parliamentary debate wasn't just for or against. It was more about what kind of law is needed, how much power is to be granted, how fast is it to be enacted, and what safeguards are considered necessary. Premier of New South Wales, Chris Minns, said these powers are proportionate. They are not about suppressing views, they are about preventing intimidation, escalation, and violence. Attorney General Michael Daly concurred and said this is a targeted, time-limited measure. Minister for Police and Counter-Terrorism Yasmin Kaitley, in his speech, emphasized that the bill was about increasing oversight and minimizing risk, ensuring police have the tools they need. On the other hand, independent member Judy Hanna condemned the terrorist attack, but warned about making laws in the heart of grief, criticized bundling multiple issues together, and called for evidence and consultations, arguing rushed lawmaking can create unintended consequences and weaken trust. Former Civil Liberties Award winner Paul Gregory pointed out that the new law established the draconian blanket ban on protest, which may collide with the implied freedom of political communication. A coalition of civil society groups were reported to raise concerns that the law was designed to take away the right of the pro-Palestinian movement, while there was no evidence that the pro-Palestinian protests contributed in any way to influence the Bondi massive murder, and the killers were rather influenced by ISIS. The speeches in the parliament showed two main fault lines. Some members wanted stronger measures on symbols and policing powers. Others wanted broader scope or greater safeguards, especially in how offences, penalties, and protest restrictions work. Now let's walk through those actual amendment battles. The running record for the Legislative Assembly shows multiple amendments were moved on the bill's second reading. However, the majority of them were rejected. For example, the opposition proposed to amend Section 93ZA of the Crimes Act to penalize any person who displays a Nazi symbol. But when we look at the existing legislation, it only restrains displaying Nazi symbol adjacent to Jewish school, church, and museum. It qualifies the geographic scope of activities that may be deemed as criminal. The opposition also unsuccessfully sought to prevent assembly targeting major facilities, including Sydney Harbour Bridge and the Opera House. This seems to be designed to counter events like Sydney Harbour Bridge protest in August 2025. When you look at the original definition of Section 214A of the Crimes Act, the major facility is only defined to include railway stations, private ports, and infrastructure facilities providing water, sewage, energy, and services to the public. Similarly, amendments were sought to disallow people to wear masks during public assemblies and require the organizers to pay costs to police in advance for repeat public assemblies. But those amendments again have not been accepted within the Legislative Assembly. Do you consider those amendments are reasonable and necessary to be considered in the future? Or are they excessive and interfere too much with the political freedom? Eventually, in Schedule 4 to the bill, it amends Section 19A of the Law Enforcement Powers and Responsibilities Act, so that police is only empowered to require masked attendees at public assemblies who are suspected of any offense to remove face covering. So why were they rejected? Well, the government's consistent position, as reflected in the speeches, was, firstly, there's an urgency over breadth. The immediate law as introduced was considered proportionate for an emergency context. Secondly, the law is avoiding overpenalization. The government expressed concern that increasing penalties and mandatory indictments could create excessive burdens or unintended consequences. Thirdly, there is requirement for policy coherence. Expanding offences broadly at this stage could delay the entire package, a risk the government cited as unacceptable in an emergency and the tight pressures. The only accepted amendment is proposed by Ms. Sue Higgins of Greens. She is the former Principal Solicitor and CEO of Environmental Defender's Office. Her amendments focused on prohibiting or restricting issuance of firearm license to persons investigated for terrorism-related offences or residing with someone so investigated. Her proposal is reasonable and considered as minor, therefore getting passed overnight just before Christmas. Now to the practical question. If you are not a politician or a constitutional lawyer, where do you actually feel this law? You will feel it in three places. Firstly, what you can display. Secondly, how protests can be policed. And thirdly, what firearm owners must do next. First of all, if someone knowingly displays a prohibited terrorist organization symbol in a public without reasonable excuse, that's now a New South Wales criminal offence. The terrorist organisation will be listed under Division 102 of the Criminal Code and related regulations, not merely controversial, extremist or radical. This can affect demonstrations, counter-demonstrations, online to offline activism, and proactive trolling in public spaces. Secondly, public assembly restriction declarations can restrict authorized gatherings in defined areas after declared terror incident. Protest planning now has to treat declared areas and declared periods as real legal risk zones, and compliance disputes can escalate quickly. Thirdly, for firearm owners, the Act shortened the license periods from 5 years to 2 years, recategorized certain firearms, kept general possession to 4 firearms with exceptions, and altered review channels. Stronger identity verification and post-death arrangements have also been added. It has been characterized as the most significant tightening in New South Wales since 1996 reforms, with clear policy intent of reducing mass violence risk. While New South Wales has moved fast, the Commonwealth government released a 2026 exposure draft that covers hate, extremism, migration and gun reform at a national level. This creates a dual layer of law. New South Wales law applies within the state and shapes policing and criminal offences locally. Commonwealth law applies nationwide and has additional scope tied to the federal powers. There are some overlapping areas and differences. For example, the Commonwealth Bill expands visa refusal or cancellation powers for people who spread hate or division or might do so. We may discuss the Commonwealth's legislation in the future video, so follow us so that you won't miss it. At the same time, national commentary has flagged that hate speech and gun reform bundles can trigger free speech and constitutional arguments, debates that will inevitably color how people judge New South Wales protest restrictions too. There are some comments that the Act is anti-democratic, but we need to take into account a few factors. Number one, the government is under massive pressure to take immediate actions at the time. In Parliament debate, the dividing line isn't safety versus no safety, it's how much power, what safeguards, and whether urgency justifies the speed and bundling. They were also about balancing individual liberties with community safety in a moment of crisis. Multiple amendments, including tougher single penalties and changes to process rights, were proposed but ultimately not accepted in favor of the government's emergency package. Number three, it is true that public assemblies in designated areas can be prohibited and no court can authorize the protest during the declaration period. But courts still remain available to review the criminal charges and any constitutional challenges. Number four, democracy requires security, and the legislated purpose is to protect democracy from violent disruption at sensitive times. From this view, the bill is democracy preserving, not democracy eroding, as well stated by the Australian Bar Association. We stand with the members of Australia's Jewish community who are the direct targets of this terrible attack. Jewish Australians are entitled to live in a society free from fear, intimidation, and violence. I think this should apply to any peaceful Australian, regardless of ethnic background, religion, or social status. Do you think the New South Wales Act is a prompt reaction to crisis and addresses the most key issues, or have a long way to go? When laws are passed quickly after tragedy, how do we make sure they actually make us safer, without giving governments more power than they need? Let me know your thoughts. I will see you next time.